And good afternoon to all. My name is Rugi. I am your treasurer, and I'm here to host for today's regulatory webinar. And we all know Dale very well, and we continue to be fortunate and grateful to have Dale Atkinson on an ongoing basis. Just briefly highlighting Dale's background, as we know him very well, but just in case there's new attendees, Dale received his law degree in Northwestern School of Law, Portland, Oregon, and is the sole managing member of Northbrook, Illinois law firm Atkinson and Atkinson that represents various associations of regulatory boards. Just a couple of reminders, housekeeping. Dale prefers to be very dynamic with this presentation. And so you can either put an entry in the chat session. It'll be my responsibility to monitor the chats. Or you can actually unmute and ask a question. Before we proceed, I would just like to highlight future educational offerings. One would be this November 6th at 4 p.m. Eastern Standard Time. The webinar is This Could Never Happen to Me, Protecting Yourself and Preventing Sexual Misconduct. It'll be presented by Samantha Mon Johnson from the Minnesota Board, Sarah Peru, investigator from Oregon, Stephen Curley from Kentucky. He is an executive director. We also have another webinar to end the year, December 18, 2024. Dale will again present us recent rulings, real impact, navigating the regulatory landscape. Dale will analyze key recent judicial rulings relevant to the regulatory community. As always, please sign up for both of those webinars through the portal as you just did today, and thank you. So now I'd like to introduce Dale as he presents today's regulatory hour topic, the fourth branch of the government, the state of administrative state. We will delve into the recent Supreme Court decision on the deference doctrine and its implications for the regulatory power of boards and agencies, and gain insights into the critical shift and its potential effect on your professional practice. And with that, I'm going to defer to Dale, and welcome, Dale. I appreciate you.
Ruby, thank you for that introduction, and everybody, hopefully you can hear me. Somebody give me a thumbs up. I can see a few of you, so if projecting, great, and you can see the screen. Welcome to the October 2024 regulatory hour of FSBPT. I enjoy doing these hours, and I'm hoping that we can share some information back and forth. As mentioned, if you have something to say or you want to put it in the chat, either way, if you want to unmute, or Ruby and staff will keep track of that chat feature in case there is something that you want to express or challenge or question, whatever the case might be. So first off, I do want to recognize and thank the FSBPT, its board of directors, for all that it does for your organization, certainly to the staff as well for operationalizing all the programs, including these webinars. And so a big shout out, thanks. But the biggest shout out thanks has to go to each and every one of you who are on the line today for your role that you play, the important role you play in public protection through enforcement of the Practice Acts and regulating the professions themselves, including obviously physical therapy and physical therapy assistants. So a big shout out, recognition from me, thanking you for what it is you do back in each of your jurisdictions. And it's you're a board member, a volunteer board member, whether you're an administrator, executive director, an inspector, an investigator, an assistant attorney general, or anyone else. We need to recognize ourselves. We need to recognize you for what you do. And I'm so pleased to have you all on today, because part of, I think, the regulatory community, the role of the regulatory community is to demystify what it is regulators do and what regulatory boards do. So I'm hoping this heads us in those directions and everything that I talk about. But again, if anybody has any comments or questions, feel free to make those. And whether they're on topic or you want to talk about anything else, that's certainly fine as well. So just to get us started, it's hockey season now. You all know that I'm a hockey fan and all that. So if anybody, and this is to make sure, one, you're listening, and two is that you know how to use the chat feature, go ahead and type into the chat feature your hockey team if you follow one. So I appreciate that. So I'm starting to see those come through. So again, thanks for, we've got a Blackhawks fan. Excellent. Although Rich is not on the line, I usually do pick on Rich. I don't like to do it when he's not here, but there's a picture of Rich right there thinking he's a hockey player, so we can chuckle at that. As mentioned, I'm Dale Atkinson. I'm an attorney, and I represent a whole bunch of FSBPT-like organizations, and so I've made my entire 38 career out of this, if you will. I see the Lincoln Stars. That's I think it's a USHL team. So excellent, excellent. We have a nice mix of teams that are going in here. So I represent a bunch of FSBPT type organizations, and they're all not-for-profit membership organizations, and most of them develop, administer, score, and maintain uniform licensure exam programs, along with many, many other programs. Some of them are educational in nature, like what we're doing today. So welcome, and that's a little bit of background about, at least about me. Today's topic is it can be an interesting topic, and it may have an effect back in your jurisdictions, but I do want to emphasize that the deference doctrine and the Chevron case and the Loper case that overruled Chevron, this is where we're heading, by the way, is really
Technical issue. There we go. I think Dale might be muted.
Yep.
me. How about now? You can hear me? It was just muting on its own. I didn't do any of that. So all right. Sometimes it's better when I'm muted, by the way. So maybe there's a sign here, you know, that's an indication, but I can see the audio designation on my screen, but I'm not watching it. So if I get muted again, just start talking, somebody do something. So so anyway, so back to this topic now, this whole deference topic and the Chevron deference doctrine from 1984 was overruled in June of 2024 this year. And so that's kind of where we're heading. And this will make this, I think, a topic that's relevant to us and you, the regulators, no matter what profession, but in physical therapy and assistance in particular, is how your agency, your board is viewed if there's a challenge to a decision that is made. And that's the basis behind this. You all are on boards or participating in a board somehow. You bring expertise to the table, and I know some of you are public members as well, but you bring expertise to the table that provide this efficient and effective method of regulating a profession or multiple professions. So what deference is given to decisions made by your boards is kind of the big picture issue to put onto the table. But I think before we get to that, it's worthy of discussing some of the even bigger picture issues. And while this is basic, it's always good reminder there are three branches of government: legislative, executive, and judicial. I think we all know what they do. The legislative branch enacts the laws, the executive branch enforces the law, and the judicial branch interprets the law. And there are some that argue that the administrative branch, if you will, the administrative arm of the executive branch, which is where you all fall, is this fourth branch of government because of the power that administrative agencies have. And you may agree with that, you may disagree with that, but that's the basis behind at least some of the both legislative and judicial actions that are being taken across the country. And we're going to get to how this applies to the states near the end of the session. But in general, we know there are these three branches of government. And well, what role do you play as the administrative arm of the executive branch of government? So that's what we're at least thinking. And again, basic, but worthy of continuing to emphasize, is the regulation of the professions is granted to the states through the 10th Amendment of the U.S. Constitution. All those powers not specifically designated to the federal government fall to the people and or the states. And so that's why there are 50 plus jurisdictions that regulate physical therapy and the practice thereof, or human medicine or veterinary medicine or any profession that you can think of. And so that 10th Amendment drives the decision-making back to the states, and then the states enact laws that protect their own citizens. Now, the FSBPTs of the world this is where they play such an important role to help provide uniformity to a process. And it may be applications, it may be data management and storage, it may be uniform licensure exam programs, it may be renewals, continuing education. There are so many aspects of this, which again, I applaud each and every FSBPT-like organization for not only these programs, but providing us the opportunity to interact like we are today. So a big shout out again, thanks. Your state boards now are executive branch appointments, generally across the board. And so you're not elected, you're an unelected official that is delegated with really what is pretty significant authority in decision-making of granting a license, denying a license, renewing a license, taking the adverse action, promulgating regulations, outreach, education, all the things that, important things that you do as regulators. So it's driven now to the states, it's driven through an appointment process. Some argue that unelected officials in the administrative branch have too much authority. So again, that's the basis for where we're heading, at least in our discussions today. And then one more basic kind of premise that a foundational information that we ought to chat about quickly is just the difference between similarities and differences between civil, criminal, and administrative actions. And so a very, very quick overview. Civil actions, who benefits from a civil action and who is, if you will, harmed by a civil action? It's usually just the two parties. Rarely is there a civil case that has some far-reaching societal impact that provides for a basis for increased public protection or anything else. And so civil matters are two parties having a dispute, somebody wins, somebody loses, lawyers get paid, and the case generally then is over. Criminal proceedings are for the benefit of society as a whole. And so if Dale violates a criminal statute, and society is better off if Dale is subject to some kind of punishment, including an up to incarceration, well, society may be better off. And so the criminal prosecution of individuals is premised upon the needs of society as a whole, and the benefits of ensuring there's a just society, and that those that cannot conform to these laws are somehow subject to control, if you will, or some kind of an adverse action. Administrative proceedings are really the same as criminal proceedings. There are some differences, but it is premised upon the needs of society. Society is better off if Dale doesn't have his license, if Dale doesn't get his license, or if Dale loses his license because of some acts that he has undertaken. And society then as a whole benefits from decisions by administrative bodies. And those can be adverse decisions in a licensure action, so a removal of or a sanction by a regulatory board. It could be deciding that Dale doesn't get a license, or it could be deciding Dale's license is not renewed. And certainly it could be decided through promulgation of rules and regulations that allow the regulatory board to better function more efficiently and effectively. Now, civil cases are decided on a preponderance of the evidence. Criminal cases are generally by the preponderance of the evidence. Some of you may have a different standard, like clear and convincing or substantial evidence, but generally it's a preponderance. Criminal matters are decided by beyond a reasonable doubt. And that higher standard that needs to be met in a criminal setting is because of what's at stake, which is loss of rights, incarceration, and otherwise. And then administrative proceedings, in your world, you ought to know what your burden of proof is. Likely it's a preponderance, more likely than not is what that means. And so there are some similarities and differences here that are at stake, but these are foundational principles that we need to understand as we navigate our way to address the role of deference and the role of a regulatory board, and then the role of the judiciary in the event of a challenge to a decision made by the board itself. And so when we think about deference, I guess we have to define it, or try to define it in some way. And the respectful submission or yielding to the judgment or opinion of others. And I think it's pretty obvious, and we all know this, but worthy of saying out loud, and that is regulatory boards are populated with licensees and public members. They are populated with, in part, licensees to provide expertise in the decision-making process. And expertise provides efficiencies to that process. So very quickly, going back to the civil proceeding that I was talking about earlier, and that is if Apple and Microsoft are having a complex intellectual property dispute over software and others, believe me, the jury knows nothing about software and other products. So in a civil setting, what has to happen is you educate the jury, you educate them on the issues at stake, you educate them on what went wrong. The defense says its side of it, and then ultimately a decision is made, but there are no experts involved. In fact, if experts were in the jury pool, they would be disqualified most likely. So now back to this deference principle is there's deference to regulatory boards because you are experts. You're recognized as experts, and you use that expertise in all settings of your regulatory responsibilities, promulgating regs, which might interpret scopes of practice or modalities of practice, and then certainly in administrative prosecutions of individuals who are accused of having violated the Practice Act itself. And so, so this deference principle now comes into play as to a decision is made and there's a challenge to that decision. Well, how do we look at that? How do we, well, I should say, how does the judiciary look at the decision that was made by the board? And to what extent should the judiciary defer to the expertise of the board? So we're laying some foundation here for the big picture issues here. And the reason this may be important, this issue is important, is because of ambiguities. Now, there are always going to be ambiguities in the law. And as you read your practice acts, you will start to identify what those ambiguities are. Some are by design, and some are not by design, and it's just a drafting issue that is subject to multiple interpretations. So what is ambiguity? The quality of being open to more than one interpretation. And this is the important role that regulatory boards and you as board members play. And so this part of this definition here is we can detect no ambiguity in this section of the act. So it's truly looking at legislation, perhaps, insofar as that definition is concerned. And so, as mentioned, there will always be ambiguities in the law, and you will read them and see them. I will read them and see them. And it's important that you know that your job is to interpret these ambiguities and ultimately arrive at whatever conclusion you need to arrive at. And that may come in the form of a rule promulgation. It certainly may come in the form of a adverse action or a disciplinary action that is potentially going to be taken against an individual accused of violating the Practice Act. So the chuckle of the day is you get paid all that money to serve on those boards is to make these important distinctions and interpretations that need to be made. So across the board, you can see you rule make, you look at scopes of practice, you may decide good moral character questions. There's delegation principles at stake, supervision, use of assistance. You can make a long list here where interpretations are always going to be happening. And that's the important role that you play as board members on those, those regulatory boards. So now, with all that foundational issue laid, why are we talking about this topic? And in general, we're talking about this topic back to that deference. And I've already said it, but I'm going to say it again, and that is boards make decisions. Those decisions may be challenged. And what role does the judiciary use in determining whether to follow what the administrative agency determined or not? And so at what point does the judiciary defer to the expertise of the board and board members themselves? Now, it's important to distinguish here between some of the decision making, and I'm going to focus on an adverse action or the investigation and ultimate administrative prosecution of an adverse action. And I will certainly admit here today that everyone on the line probably has a little different process as to who ultimately makes these decisions. And so you may have hearing officers or administrative law judge. It may be hearing commissions that matters are referred to. It may be the board, you all itself, subject to conflicts and recusals and everything else. So we all have to take this information with a grain of salt and figure out how it works within each of your jurisdictions. But in the end, ultimately, there are several factors to a finding of wrongdoing on the part of a respondent, we'll call them. And I use respondent instead of licensees because of the unlicensed practice questions that might surface. But so those factors within a final ruling include findings of fact and conclusions of law. Okay, and if we go on, it'll include findings of fact, conclusions of law, burden of proof. It'll include the sanctions with specificity. It will include reinstatement rights, if any, as opposed to permanent. It will include publicity. And in general, I've learned to add to my list to say it will include the notation that it is a disciplinary action subject to reporting. So if you follow those 7 steps, you're going to have a well-written final order. But for today's purposes, we're going to focus on findings of fact and conclusions of law. So the case, the deference principle in the cases we're about to talk about will focus on the conclusions of law. And they'll focus on the interpretations of ambiguities in statutes. They do not focus on the findings of fact or the fact finder decisions made by you all as regulators, the administrative law judge, the hearing officers, or the commissions themselves. And so we focus on, that's why I put those asterisks next to conclusions of law, that the relevance of the Chevron deference principle and the ultimate overruling of it in the Loper case this year, in June of this year, is really an interpretation of statutes. It's interpretation of ambiguities that may exist within the law itself, and whose job is it to determine that, one, and then 2 is, must the judiciary give deference to the decisions of that board related to those conclusions of law? So and then the last principle, I guess, to talk about prior to these cases is that we're talking about the Loper, the Chevron case overruled by Loper is federal. These are federal administrative procedures. This only applies to the federal government. It does not apply to the states. However, some states will follow the principles of the federal government when it comes to issues like this. So there may be an effect on you. There may not. Certainly, the sky is not falling, and we don't want to overreact to what this case actually determined. But it is federal driven, and you all are driven by your State Administrative Procedures Act. Every state has one, and so you will focus on the state issues that may surface in response to the case itself. But so it's conclusions of law, and it's driven only in the federal system, not the state systems. So in 1984, the United States Supreme Court rendered a decision that was really not all that remarkable in the eyes of the legal community, but it ended up being a significantly cited opinion that affected federal agencies and the roles that they play and the deference given to them. So the Chevron dealt with the Clean Air Act of 1977. The Environmental Protection Agency promulgated some regulations without worrying about all those details. It had to do with pollution and standards that states were subject to, and these were air quality standards that the Clean Air Act was attempting to address. And so in the ordinary course, in 1981, some rules were promulgated, and those rules required certain states to have plans in effect for non-conforming industries that existed. So it was a let's call it a reaching. These were regulations that reached into and affected the industries that existed. Well, Chevron challenged these rules, And the Court of Appeals had set aside these rules as not squarely addressed in the Clean Air Act. So it truly got to the heart of, well, what authority does the EPA have to promulgate regs that were interpretive and or expanding of the intent of the Clean Air Act of 1977? So straightforward, so far, opinion out of the Court of Appeals, but it was then appealed up to the Supreme Court, which reversed, and it held that a court may not substitute its own construction or interpretation of a statutory provision for that of the reasonable interpretation made by the agency, the administrative agency that would be akin to you all at the state level. So again, it seemed to be a decision that was not necessarily that remarkable in the time, but as you can see, it has been cited over 18,000 times, and it is a significant decision by the US Supreme Court to create this deference standard. So it is a common law principle, meaning it was judicially created by the opinion of the United States Supreme Court. So you can see on the slide here that under the deference standard established in the opinion of the Supreme Court upheld the EPA's interpretation of the Clean Air Act and allowed them to promulgate this regulation and actually enforce that and place it into effect. An important decision made in 1984. It created a two-part test with some flexibility to these federal judges, but the two-part test called for the court to examine the wording and the context of the statute, and if that wording and context is clear, follow the intent. This seems pretty common sense, by the way, but it's part two that became important. And if the statutory language is ambiguous, the reviewing court must defer to the agency's interpretation. Okay, so that's a significant recognition of an administrative agency who are populated through an appointment process, not elected, that potentially are making some significant, important decisions. So this case then carried forth and has been cited, as I mentioned, thousands and thousands of times. And as noted by the court here, the deference principle rested on the presumption that Congress, when it left ambiguity in a statute meant for implementation by an agency, akin again to you all at the state level, understood that the ambiguity would be resolved first and foremost by the agency and the desired agency, not the courts, to possess whatever degree of discretion the ambiguity allows. So it was authorizing these agencies to then make these interpretations and courts to be bound by them. So you can see they asked down at the bottom there, are statutory ambiguities implicit delegation of interpretive authority to the agencies? I might suggest the answer to that is no, but this is the question that has been asked over the course of time since 1984, ultimately leading to the Loper case. And as has been stated here, the Chevron case demands that courts mechanically afford binding deference to agency interpretations, including those that have been inconsistent over time. Because remember, agencies change, personnel changes, administrations to the presidency change, and otherwise, and there may be different approaches to what is the exact same language that exists on the statute in the Clean Air Act, for example. Of course, the legislature has the right to amend or change or enact new laws that address this, but we all know that that process can be cumbersome, slow, obviously politically driven, and sometimes things don't get done that perhaps we would like to see done or maybe should be done. So this recognition issue is what's at stake here. So along comes the Loper Bright Enterprises case here that was decided, as I mentioned, in June of 2024. It was a challenge to a rule of the National Marine Fisheries Service, which was promulgated under the Magnuson-Stevens Act. And this is a fisheries issue. It has to do with catches and sustaining our oceans and others. And so there's an element similar to the Clean Air Act to conservation and otherwise. And as a quick side note, my daughter is, she works for NOAA, and part of her job is to work with the National Marine Fisheries Service. So that's not necessarily a disclosure. There's no conflict, but just a little side note there. So the National Marine Fisheries Service promulgated regulations that required fishing vessels to carry and pay for observers on board who are collecting data about catch limits and fish species and otherwise. And again, in an attempt to enforce the conservation-driven issues in the Magnuson-Stevens Act. So a little foundation there. And the district court and the Court of Appeals upheld the rules following the Chevron deference common law principle we just talked about, and that is deference to the interpretations of ambiguities in the act, and you give that deference to the agency itself, in this case, the Fisheries Service. So now the Supreme Court is readdressing the issue of the deference principles that were established in the Chevron case in 1984. And the Supreme Court held that the Chevron approach was misguided. So similar to changes in administrations, changes in agency members, changes in political processes and changes in political views or anything else, here now the Supreme Court was asked to readdress an issue that it adopted in 1984, and this will happen on occasion. And ultimately, the Supreme Court said this approach, the Chevron approach, was misguided. It was inconsistent with the Federal Administrative Procedures Act, and it was inconsistent with the fundamental principles of the separation of powers. Who has authority, who makes decisions, recognizing that legislative, executive, and judicial branches of government. So the Supreme Court vacated and remanded the Court of Appeals decision. The Court of Appeals had affirmed the district court and had upheld the rule. And the Supreme Court very clearly said they are overruling Chevron and now recognizing that the judiciary has the ultimate decision-making, I shouldn't say decision-making, the ultimate interpretive authority of ambiguities held within the statute itself. And this is the Federal Administrative Procedures Act that the court relied heavily upon. And you can see under 706, that first bullet, the reviewing court, so this would be an administrative decision that is being challenged. And let's say this administrative decision is interpretive of ambiguities in the statute and it's being challenged. The reviewing court shall decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning or applicability of the terms of an agency action. So that's a powerful statement. That's a broad statement, and it certainly does recognize the judicial authority to ultimately make these determinations. And the Federal Administrative Procedures Act is legislatively enacted, so therefore it's following the legislative branch of government, et cetera. And so this, along with other principles, but this is mainly where the court focused related to now the overruling of the Chevron deference doctrine. So then we ask ourselves, okay, fair enough. Now, how does that affect you at the state level? As a quick reminder, you regulate the professions because of the 10th Amendment. And so now, what kind of deference principles might exist within your jurisdictions related to a challenge of an interpretation by a regulatory board, a board of physical therapy, of ambiguities in the statute? Okay, so the best I could do is citing, as of 2020, a couple of good larger articles. So what I'm talking to now is how issues were in 2020. So it's a few years old, but these are probably holding true generally. And that 14 states and the District of Columbia recognize a Chevron type deference. And again, as a reminder, meaning that the judicial branch of government defers to the interpretive decisions made by the agency, the boards themselves. 25 states have a de novo review. De novo means the court starts over, wipes the slate clean, and it reviews the challenge or the issues at stake and ultimately makes the decision itself. So that de novo review. And 11 states have some kind of a hybrid, and we'll get to that on the next slide, but it's kind of a mixed issue that related to that. Now, nothing prohibits a court from recognizing and giving weight to the agency's interpretation. So that's not really the issue. The issue is a mandate versus a non-mandate. That's how I look at it, but it's probably a little more complex than that, but we'll break it down as simply as we can today. So the 14 states that follow the Chevron approach, again, as of 2020, are listed here. You can find your jurisdiction if you see you're in there. And the Chevron approach is, again, that deference to the agency's interpretation of ambiguities in the law itself. Remember, we're focusing on conclusions of law, not on findings of fact. So we'll keep that in mind. 25 states, these are the 25 states that follow that de novo, start all over approach. And importantly, or at least I think of relevance of late here, and I think there have been movements legislatively and otherwise to address this deference principle. So it's not necessarily a new issue, but it may be subject to changes within your jurisdiction. So you can see the highlighted Arizona and Florida. Arizona moved to a de novo approach through the enactment of a statute, likely some administrative procedures law. And in Florida, they moved to a de novo approach via a constitutional amendment. That's a significant issue that was determined, at least in Florida, to be worthy of a constitutional amendment that now recognizing a de novo approach so that there is not a mandate of deference to the agency's decision or interpretation, the board's interpretation itself. And then, again, out of the 25 states that follow this de novo approach, California, Louisiana, Maryland, and Massachusetts have some kind of a modified de novo approach where they give weight, not deference, to the agency interpretation. That's a common sense principle in my mind, and it's probably done across the board, but it's actually identified in those 4 jurisdictions. So this gives you some idea back in your home state as to how you might be approaching, or how the judiciary might be approaching challenges to your decisions as regulators, interpretive decisions of the statutes that exist. And then the hybrid approach is a creation. You remember the 2-step part we talked about several slides ago. Is there's a step 0 where the federal court asks whether the Chevron framework applies to a certain situation. So there's an added step there that may eliminate the need for Chevron or not, but they call that a hybrid. These are the hybrid states that exist. Again, the judiciary will potentially give that weight to the board, or to the regulatory agency or the board itself, but not be bound by it itself. So now we ask ourselves, is this good or bad? Okay, and when I say this, is the Loper case that overruled Chevron from 1984, the Loper case of June of 2024, is this good or bad? And you're all going to figure that out. What about board expertise? Is that needed? Well, are the board's experts in interpreting ambiguous statutory language? Maybe, maybe not. Boards are certainly experts, and they should be, in the profession that they are regulating, in physical therapy and physical therapy assistants. You bring to the table that type of expertise. As I mentioned, that expertise adds efficiency to the process, okay? Whether you're promulgating regs or sanctioning a respondent. So what about the board expertise? Should that be taken into consideration? I'm sure it should be. But should it be recognized as under a deference principle as a regulatory, or excuse me, a judicial court must follow it? And how far can that expertise go? Now, here's one place where I think that the Loper case will have an effect on your worlds, even though Loper is federal, your state. You saw the identification of the state approaches, and that is the less expertise potentially, arguably needed on a board the more likely, perhaps, the more likely approach by the governor, the executive branch of government, of appointing public members rather than licensees. So let's clarify that just a little bit. We know the statute will say 7 members of the board, 5 of which shall be licensees and 2 of which shall be public, something along those lines. So there would have to be some statutory changes, but let's just talk philosophically for just a second. And the movement across the U.S., somewhat since the North Carolina State Board of Dental Examiners case, the movement is perhaps diminishing the number of licensees, increasing the number of public members, because maybe the legislature doesn't trust licensees to regulate their own professions. And I purposely avoid the phrase self-regulation. The professions, in my mind, are not self-regulated. If they were, government will step aside and say, go regulate yourself. That's fine. So one of the issues I could see at stake here is how regulatory boards are populated. And if expertise is not relied upon, does that give incentive to the legislature to change the law and the executive branch to appoint public members over, if you will, licensees? That may be a stretch, maybe, but that's a worthy point to be thinking about. The less expertise on the board, well, what about promulgating rules and regs? And those rules and regs have force of law. So we do need this expertise. We do need those licensees involved, I think, in the process. So I'm not suggesting there should be less licensees and more public, but where are we going to land on that? And so it all comes down to this board composition that is in law. So if the composition is going to change, it'll take a legislative change. But we saw quite a reaction to the North Carolina State Board of Dental Examiners case, and a lot of that case was driven on dentists accused of protecting their own turf and not allowing others within the teeth whitening industry, so that you create economic advantage to licensees, to dentists. So I think you all remember that case, and we talked about it a lot related to that. So now what? One is seek advice from your counsel. So what I'm doing here today is providing you with some information, some educational things, not legal advice. Seek advice from your counsel and understand if your state is a de novo state, a Chevron state, and then ask these questions, or a hybrid state, and ask these questions. Does that Loper case affect us? Should we be worried about it? Well, maybe that's not the right approach. Should we take it into consideration related to decision-making? You're going to ask that question. You definitely have to understand the board's role, and you should understand that anyway. And so what role does the board play? What role do you play individually, licensee? What role do you play individually, public member? And of course, as a group decision-making. Certainly, you have to fulfill your obligation of carrying out the intent of the enabling legislation, the Practice Act. You are creatures of statute. You were created by the legislature. You were authorized and delegated with authority. Well, you're going to take that authority seriously, and you're already doing that. I know that. And you're going to carry on and not be intimidated by the Loper case, and not be intimidated to the potential for challenges to decisions that you make. So make those decisions, group decision-making, and follow through on those. And definitely do not overthink this issue. Okay, we don't need to overreact to this, because it's a state-by-state driven issue, and the Loper case is a federal issue. I don't see that much filtering down, but it might. So, but don't overthink it, and continue to undertake your roles and responsibilities as board members themselves. So this is my last slide. So I'm happy to open this up to any questions that anybody might have. You can type them in the chats. I can see the chats. You can unmute and speak if you'd like. Or you can get an extra 15 minutes of your life to move on from the session today. But anybody have any comments that you'd like to say, or questions you'd like to ask?
Dale, this is Kathy Arney, and oops, Am I unmuted? I just want to make sure.
Yep, yep, I can hear you.
Yeah,
Kathy, I can
so
hear you.
great. So in North Carolina, you know, we live with the dental board case all the time, but we experienced this firsthand at the PT board, and this is how the decision was made in our North Carolina Supreme Court when the acupuncturist sued the physical therapist over dry needling. And in the end, the Supreme Court did say that not just PT, but all occupational licensing boards, and I'm sure it was more healthcare related, you need to stay in your lane and you can make the decision about what is in your scope of practice, because there's expertise on the board that is not able to be made necessarily at the legislative level or rulemaking level. And so that was great in 2018. And now we would not be going to a court. We'd be going to the Office of Administrative Hearings, which I guess is a court of a different kind, if something like this happens again. So it'll be interesting to see what's changed, if anything, because even though the dental board case happened in North Carolina, to my knowledge, there have not been changes to the composition of boards. So my hope is that there's still this hybrid decision-making process, because, you know, I of course, we were on the winning side, so of course you're biased, but, you know, it felt pretty effective to me.
Yeah, yeah, and there's some really good points that Kathy's making there too, but my reaction to what you just said is one of a couple things. One is embrace and recognize overlapping scopes of practice, and when boards say only we can do this, only physical therapists can do this, only veterinarians can do this, to the exclusion of everyone else, that draws attention both legally and legislatively. So embracing the overlapping scopes is just really important. Now, when boards fight with each other, that's a bad situation anyway. Acupuncture is fighting with PT, and when it's the regulatory boards fighting, and nobody's going to win out of that. But you know, you bring up some great points as now how this will start to affect North Carolina, you know, under these circumstances. But I suggest to everyone on the line today is that there are overlapping scopes, and you're going to have to recognize those to the extent that the statutes are being interpreted. And so just don't interpret your statute where there's ambiguities, especially in scope, to say only we physical therapists can do this, to the exclusion of others. You interpret it to say physical therapists can do this, period, and you're done. There may be another board that interprets it as well. And you know, to Kathy's point as well, I just finished up writing a newsletter article for another client, and the article focused on what someone called animal chiropractic, and the dispute was, well, does the chiropractor have the authority to work on animals, and does the veterinary board have authority over an unlicensed veterinarian / licensed chiropractor? So these are just scope issues, but you know, thanks for those comments, Kathy. Good points. I think I addressed them. Yeah, go ahead.
This is Sonora. I'm in DC, which is a whole new bag. We just did something which should test a lot of the working together. We've combined boards, so PT, OT, and speech are together, and it's new. But what do you think, what did you know about the district and what way that it works? Because remember, Congress can overturn anything we do. So
Sure.
do you have any experience with it?
Yeah, and the same is true in any other jurisdiction too, is if the legislature doesn't like what a board's doing, it has multiple approaches of changing the law. And I know it's easy to say, maybe not easy to do. The executive branch has the right to just probably disband or, you know, kick everybody off the board and appoint new people. So that might happen too. But Sonora's bringing up a good point too, is these composite boards, if you will, where you have multiple professions regulated by one board. And those are really interesting to watch operate, because you might have 2 physical therapists, 2 occupational therapists, 2 speech language, and then maybe a couple public members. And there are efficiencies built into that, but you just do not want to get into PTs fighting with OTs on the board itself just over, say, a scope issue or a speech issue. It doesn't look good, it doesn't feel good, and that is going to lead to both probably political issues legislatively, but maybe legal issues as well. So we see this in other professions, in the mental health services, social work counselor, marriage and family therapy on one board. And does it work? How do you split the expertise up? Who's best? So, I'm not gonna, give an opinion on whether that's a good idea or a bad idea. You have to live with it because it's already happens. And so, the advice, if that's the right word to say, my opinion on this, same thing with Kathy is you got to stay in your lanes. You got to figure out what it is regulate, but you're going to do what's best for the public overall. And you're not going to fight with occupational therapy members on the board itself. It might happen occasionally, but it's kind of to your point too, Sonora, and that is, and I say this in jest, but if I were a governor of a jurisdiction, I might take the chiropractic board, make it the medical board, and I might take the medical board, make it this nursing board, and take the nursing board, make it something else. And people would freak out, and you're wondering why, well, it's part of it is you want to protect your own turf. So you got to stay away from that to the extent you can. So thank you for that comment. Anyone else want to unmute or type in something like the Blackhawks are a good hockey team, or this is a really good presentation Dale just gave, or FSBPT is great. You can say that.
Dale, this is Kathy Arney again, if nobody else has any questions.
Sure.
I had a question about the ambiguity part. There are several statutes in North Carolina of large occupational licensing boards that contain the words standards of prevailing practice and ethical standards. And we kind of like that because of the ongoing evolution of the physical therapy profession. There's so much change with different technologies, et cetera, et cetera, et cetera. And how do you keep a statute current without having some bit of flexibility within it, as long as you're interpreting it within your practice as opposed to anybody else's? So my question is that one of those ambiguities that you're talking about? Is that kind of wording?
Sure. I mean, it could be. And let's take a step back to Kathy's question, and that is, statutes should be skeletal. Legislators don't know physical therapy, and they don't know human medicine. They don't know vet medicine. They should be skeletal, authorizing. They should be skeletal to create the board and then authorize it to regulate. And the board promulgates rules that add the definitiveness where necessary, allowing the ambiguities that Kathy's mentioning because evolution of technology all by itself and the practice issues. So that's how I see the process should work. It doesn't always work that way, but that's how it should work. And for those of you in FSBPT as a model act, it's kind of the same approach. But now back to her question, how do you preserve the ambiguities, but also add enough meat to the bones through the promulgation of regulations? And that's part of your answer, Kathy, is your regulations are going to address that, one. And then two is you can plagiarize from the standards of practice that maybe trade has identified or maybe FSBPT has identified and promulgate it right into your regs. But I do agree with you. You want to leave enough ambiguity so that the evolution of practice and more likely the evolution of technology and modalities can be recognized without having to change the law. And so, that's the short answer. Follow the progress, promulgate regs, and plagiarize and plagiarize is okay, by the way, plagiarize to the extent you need to, write in the regs, leaving some ambiguities, but those are precisely the ambiguities we're talking about, is your interpretive issues as the experts on the board.
All righty. It looks
And
like
Yeah, it seems kind of quiet. So Rugi, I will turn it back to you, but if anybody has anything else to say, feel free to do that. But I want to end how I started and saying thanks to Rugi and the board of directors, and thanks to the to Paul and the staff of FSBPT, and the biggest thanks goes to all of you as regulators. So appreciate you having me.
Yes, thank you. And looks like nobody has any questions in the chat. Everybody's thanking everyone. And again, thank you, Dale. I appreciate your time. And we are going to adjourn. And thank you all for attending this webinar. See you all soon. Take care.